Hello, everyone. Welcome back to our season 3. We are honored to host Advocate Ritwik Parikh, an advocate on record at the Supreme Court of India and a seasoned litigator with extensive experience across constitutional law, commercial disputes, insolvency, and criminal appeals. A gold medalist from his LLM at Queen Mary University of London, he combines strong academic excellence with a dynamic litigation practice. Over the years, he has worked with leading law firms and has been actively involved in high stakes matters before the Supreme Court, High Courts, NCLT, and NCLAT. Advocate Parekh has also represented corporate giants like Larsen and Toubro when the latter was involved in Chennai's metro rail building. He has represented the Bank of Maharashtra across forums, including NCLT, NCLAT, and writ courts, showcasing his expertise in banking and insolvency matters. As an advocate on record associated with the Supreme Court Legal Services Authority, he has also handled and drafted criminal appeals for accused persons before the Supreme Court. In addition, he has served as a panel counsel for the State of Chhattisgarh before the Supreme Court, reflecting the trust reposed in him by both financial institutions and government bodies. Currently, as a founding partner of his firm Parikh and Parikh Partners, he continues to advise and represent clients in complex and high value disputes. With his diverse experience spanning litigation, institutional representation, international education, and now global qualification pathways, his journey offers invaluable insights for law students and young lawyers aspiring to build a serious career in litigation. We welcome you, sir.
Thank you. Thank you so much.
So, to start with, you've had a diverse journey from assisting at the Supreme Court to founding your own firm. What inspired you to pursue litigation as a long term career? What were some of the biggest challenges you faced in your early years as a litigator?
See, Ritu, my father is also a senior advocate in Supreme Court. So that was my first inspiration because I saw him arguing, and I always liked the black coat and the black gown that he used to wear and go and argue the cases. That was my first, you can say, attraction towards the legal field. That was the attire. From there, when I started doing my LLB, so there were two fields during my time, and the corporate field was increasing tremendously, and a lot of people were like in MBAs after their LLM were getting placements in big law firms like Amarchand Mangaldas and big IP law firms like Singh and Singh, Anand and Anand, etc. And they were getting good packages. I mean, ranging from 70,000 a month to lakh a month. And this I'm talking about way back in 2013-14.
Yes.
So, and that was a very attractive offer. And but my inclination towards litigation was not because of money, but the fact that I am an independent person. I can handle my own clients, I can manage my own time, and I can decide what to do and what not to do and how to do it. So that independence coupled with discipline and the fact that I can argue the case, because in law firms I don't think you are allowed to argue cases in court, but the fact that you can argue your case, you can decide the case on
Mm.
merits as well as on law before the court or any tribunal was the biggest inspiration for me. The independence that you get in litigation, the it gives you not only, like you say, with great power comes great responsibility. Yes, you have your client's attention, you are on your own. That's a lot of freedom, that's a lot of power, but with that comes a lot of responsibility towards client dealing, and that everything, and dealing with clients, interacting with them. And the clients are from various fields. Some are scientists, some are engineers,
Mm.
some are bankers, etc. So talking to them, gaining knowledge, so that is in one way litigation makes you jack of all fields and king of
Yeah.
one. Hmm.
Right, sir. And you not just pursued your LLM from Queen Mary University of London, but you were
Hmm.
also a gold medalist. What motivated you to choose the UK for your LLM?
UK was my first choice, being a Commonwealth country and the similarity in laws,
Mm.
and I always wanted to go to London for my LLM. And but after my LLB, I practiced for a year under a standing counsel, And after gaining almost 1.5 year experience, I decided to now pursue my LLM. So I got
Mm.
into Kings and Queens, but I chose Queen Mary because of its IPR program. And IPR was one subject which got me interested since my college days.
Okay. And yeah, because in today's time, many students are confused between, common law countries, as you said, like UK, USA, and others. Why did you choose specifically Queen Mary University?
Because of its IPR program and the feedback I got. Like I said, I got into one or two other universities also in London, but
Hmm.
I specifically chose this university because of its IPR program. Intellectual property and the professors and the feedback I got was very helpful in allowing me to choose that university.
Right. And what subjects did you choose during your LLM? And how did this shape your specialization?
So, to my subjects, I chose very carefully because, intellectual property is one thing which is almost similar in all the nations, whether it's US or UK, Europe. So, I chose those subjects which are widely applicable across the globe.
Mm.
So, I had international and comparative patents. So
Okay.
you compare the patents law in EU, UK, and US. So that
Okay.
also covers our laws also, because basically we are all covered by trips. And
Hmm.
the other is international and comparative design law. Now design law is something not a lot of people work on, and it's a very interesting subject. The third was intellectual property, trade, and investment. So this was intellectual property coupled with commercial and arbitration matters. So this was a complex subject, but a very interesting subject. So I chose subjects which covered not only that subject but also their comparative analysis.
Right.
And my dissertation was, at that point of time, 3D printing was very common, and it was up and coming as a new technology. So my dissertation was on 3D printing spares and repairs. And for example, if you get a 3D printer at home and you start
Hmm.
making products at home, will it infringe copyright or not? Will it infringe patent or not? Will it infringe design rights or not? So that was a very interesting dissertation I had.
Right. Very interesting to listen
So these
also.
so these were the four uh, you can say subjects I had in my LLM.
Right. And how is legal education in UK different from India in terms of teaching style, evaluation, and practical exposure?
So they make you work on concepts. So yes, you should know the section, you should know the case law, but you will only understand that if you have the basic grasp. In intellectual property, you need to know a lot of basics, in the sense that as far as copyright goes, when a book is being published, the practical aspects of it. Similarly in trademark, similarly in design. So
Hmm.
they actually work on the practical aspects on how the real world works and how the law will be applicable to that real world, and not go strictly by the book. Yes, you
Right.
should know the basic definition for your exam point of view, but as far as litigation point of view, you should know more than the definition, and
Right.
that you can argue only if your concepts are clear.
Right. And is there any specific, study techniques that help you excel academically and secure a gold medal in your LLM?
No, basically, there are no specific study techniques. It's just being regular in classes and keep revising your everyday classes. That's all. And one habit which I develop is that keep notes, and
Hmm.
don't type it on laptop. It's better if you handwrite it. I feel that your memory works better if you handwrite your
Right.
notes
Right.
and then
Yes.
type it. Hmm, hmm.
Yes, sir. And did you consider working in the UK after your LLM? And if yes, why did you ultimately choose to return to India? How did your LLM impact your legal career?
Actually, I did consider working in UK, but unfortunately, at that point of time, this Brexit was happening,
Oh, yes.
and so there was a lot of confusion at that point of time. And I also got offers from one or two firms or law offices, but as a paralegal. But you know,
Okay.
Ritu, the jurisdiction matters. If I want to practice in UK, I have to clear their solicitor exam. Like in
Yeah.
India, I have to give bar exam. So law is one field, unlike any other field like MBA or anything. If I do my MBA, I can get a job in UK or Hong Kong or Singapore. But as far as legal field is concerned, you have to clear their
Mm,
bar. So the jurisdiction matters. Only
right.
then I am entitled to practice as a solicitor in UK. So
Right,
that
sir.
is one reason I came back.
And how did your LLM impact your legal career once you returned to India? And in hindsight, do you think that doing an LLM abroad is essential for a successful litigation career here?
So I'll answer your second question first. LLM is essentially LLM is actually not very important. It's not important for a successful litigation career in India. But what LLM does is a different it shows you a different perspective because you have students across the world. So you can discuss your law with their law, and it opens your mind to a different level. Plus the academic background, then you'll have the grasp of the concepts, stronger grasp. And it's always
Mm,
better if you know laws of other countries, especially international laws like intellectual property laws or trade laws, for example, arbitration laws. So these are all international laws which are applicable mostly throughout the country, mostly throughout the world. And LLM will help in that. But as far as litigation in India is concerned, it is not a
mm,
compulsory thing. And I do not, if someone doesn't want to do an LLM, it's up to him or her.
right. You've handled matters before the Supreme Court, High Courts, and various tribunals. So, what skills do you think are most critical for young litigators? And what is the ground reality of litigation practice that law schools often don't prepare students for?
Law schools, I feel, don't give the practical aspects. See, my experience,
Mm,
people who passed after me, their experience has been the first feeling that you get after you enter the courtroom after your LLB is like, कॉलेज से कोर्ट कितना अलग है.
yes,
I mean, you can't even compare that.
yes.
So through moot courts, yes, you get a little
Mm,
in-depth knowledge of how the court basic functions. But in practicality, the way you have to deal with client, because every human is different. Sometimes clients are
yes.
polite, sometimes they are rude. How to keep your calm, how to deal with judges, their temperament are different. So these are all very practical aspects, which obviously you will know with experience only. That theoretically you cannot learn anything. The other
Mm,
thing I recommend young lawyers is drafting. Drafting is very important, especially in civil matters. Drafting is
yeah.
70% of your cases. See, in civil matters, even if you don't argue and your
Mm,
paperwork is solid, along with all the annexures and all the documents, it is a high chance that the judgment or the order might come in your favor, even if you don't argue the matter. So
mm,
important is drafting. And then obviously these days everyone is very equipped with AI and techniques and all for research work. So but what I recommend is not to use AI, because what I have found out that AI is not good for legal research as far as case laws and other things are concerned. So they should know how to use either Manupatra or SCC.
yeah.
It's and SCC. There are a lot of ways to do legal research, not just by putting keywords and trying to get a case law, but there are many. There is a specific way you have to use it. So I recommend all the students to learn SCC well, and
Mm,
drafting, because drafting requires your a good mentorship and how to, it's a different skill set to draft a writ, draft a special leave
mm.
petition, then draft an appeal, then criminal matters is a different ball game altogether. So and again, that will come with if you have a good mentor and with experience.
And since you mentioned mentor, how important is mentorship in litigation, and how should young lawyers choose their seniors?
I personally believe that a young lawyer who wants to go into litigation should try and avoid Supreme Court initially
Mm.
for litigation. And even if you want to go to Supreme Court or you want to practice in Supreme Court, try and look for a good AOR and not go to a senior advocate. Reason being, a senior advocate, the clients come, the AORs come and brief them. You will not get an
Right.
opportunity to get to draft the matters. The only thing you will get, or argue for that sense, the only thing you will be exposed to is research work or how to deal with clients. That's all. But if you are under a advocate or advocate on record who's practicing in high courts,
Mm.
tribunals, district courts especially, then not only you will get a chance to appear before the court, but you will get a chance to draft and appear. The good mentor might even give you some cases to go
Mm.
and argue. The cases which are not very high stake matters, which are small matters.
Yes.
Like so they might give you cases and say, okay, you draft and you only go and argue and you
Mm.
go and file. So the practical aspects of how now e-filing is compulsory everywhere. So how to
Yes.
e-file and everything. So and make an
Mm.
account everywhere. So all these things are very important. So like I said, theoretical aspect is one thing because that is the argument side, that is the legal side, which is the last part. But before all
Mm.
that, you need to know how to draft, how to file, how to present your case on the first date of hearing. What is the main point that the court should consider to admit your case? All these things
Mm.
are very important for a young lawyer to understand and know.
Right. And since you mentioned AOR, sir, you yourself
Hmm.
are an AOR. Clearing the AOR
Yes.
exam is a major milestone. How did you prepare for it? Could you share some practical preparation strategies and study resources for our aspirants?
Yes. So in AOR, there are basically four subjects. One is Supreme Court Practice and Procedure,
Mm.
which is, I feel, the most technical subject, for which any person, any student or any lawyer who's giving an AOR exam right now, I think the exam is in June, should go and read and basically mug up the Supreme Court rules. That
Yes.
is, and the Supreme Court jurisdiction, which is the most essential because the question will come definitely from that.
Jurisdiction.
Secondly
Okay.
is legal ethics. Legal ethics is the same as what we were taught in LLB.
Okay.
Third is third is drafting. Now drafting is something which
Mm.
is a very is I think a 3.5 hour paper in which half an hour is
Mm.
given for you to read the questions and then 3 hours to draft it. So that is a very lengthy paper. So you need to have people who don't have a habit of writing should now start writing everything for AOR
Yes.
exam because a lot of people don't clear because of their writing aspects, even if they know the answer. And
Yes.
fourth is obviously the judgments. And and the other thing I would put my this I will recommend the advocates who are giving an exam right now is that they should go and attend all the lectures which are being conducted. I think it
Yes.
will be
Yes.
a few weeks before the exam, which is very important. So you'll get an idea on what sort of questions you will get, and all do the past papers also.
Right, sir. And how did becoming an AOR change your practice and professional opportunities?
It's a step above being an advocate. And earlier, when I used to file, I used to get matters in Supreme Court. I used to, ask other people. I had to go and ask an advocate on record, someone or the other, and then you'll have to also not only share your fees with him, but
Mm.
also share your case with him. And sometimes it bothers you because you think in a different way, the AOR is thinking in a different way. So now being an AOR, I am the not only I can handle a case from the district court till the Supreme Court,
Mm.
but I can also handle the way I wanted to, obviously keeping the interest of the client as paramount.
Mm.
Now, the other thing is that people across the country, they're looking for AORs to file their cases in Supreme Court. Now, once they know I am the AOR and they are in touch with me, so it gets easy for them also. And
Yes.
obviously is very helpful for me also to get more cases. And as a AOR, you're filing in Supreme Court, you get a wide range of cases from criminal to fundamental question of fundamental rights and writ petitions and
Mm.
insolvency appeals and
Mm.
so you in litigation there, yeah, one more thing, that you can't select your subject in litigation. Okay, I will take this case, I will
Yes.
not take that
Yes.
case. You cannot do that, and
Yes.
you should not do that because it's a very competitive world right now. Okay, I only take criminal matters, I will not take civil matters.
Right.
In district court, yes, if you're practicing only in district court, you have that, you can do that. But if once you go into high court and Supreme Court, I don't think
Mm.
you should do that. Yes, you can say that you are specializing in a certain field, but if I say I am specializing in IPR, I will not come and no, if someone comes with me for a bail, I'll not say
Mm.
ki, no, 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 I don't know bail, I just
Right.
know IPR. As a litigating lawyer, I cannot say that, and I should not
Right.
say that because that does not look good.
Right. And since
Hmm.
earlier, sir, you were mentioning about the solicitors qualifying examination. We also understand that you are
Yes, yes.
preparing for the solicitors qualifying examination in the UK. What
Now that is correct.
motivated you to pursue this qualification, and how manageable is it to prepare for the SQE alongside active legal practice?
So my LLM, my time in London obviously inspired me. I really enjoyed that time. But after that, I got busy, obviously, in my building my own law firm and then my own practice. Finally, I thought it's high time I should give the solicitor exam. Not only because I want to go and practice in UK, but also
Mm.
Ritu, the fact that I feel and it's high time that and you must have heard news that international law firms, India might be opening the doors for them.
Yes.
So it's a good opportunity for advocates who have an international, who have I mean, some people have cleared USA bar, some people have cleared
Mm.
UK bar. So those international firms will attract those people who have an additional
Yes.
qualification. So that is one thing. The other thing is I like to study. I like to remind myself that I am a student, and this is the best way you
Mm.
remind yourself. So I thought my AOR exam would be my last exam, but no,
Yes.
this is my. You never know. After this, I might be giving some other exam also.
Let's hope that. And sir, could you explain the step-by-step process to become a solicitor in the UK through the SQE route? And what is the approximate cost involved in the process?
There are two parts to the solicitor exam. One is SQE1, which is the written exam, which is
Hmm.
further divided into two, FLK1 and FLK2. FLK1 has, I think, seven subjects, and FLK2 also has seven subjects. So in total, 14 subjects are there.
Okay.
SQE2 is the oral interview. Now,
Okay.
oral interview is something that can be exempted. If you have the certificate of practice, if you have more than, I think, 2 or 3 years experience, then
In
that
the
is something
UK
that
or
can
in
be,
India?
no, in UK. To
Okay.
become a solicitor, this SQE2, that oral interview can be exempted if you fulfill the requirements as per the Indian jurisdiction. So they have certain
Okay.
set of requirements, and you have to get a letter of recommendation from a senior advocate, a good character certificate from your concerned bar counsel. So there
Okay.
are 3 4 documents that are required, and they take some time to scrutinize your documents. If they
Hmm.
feel fit, then they exempt you from that exam, which is a big step, because that SQE2, I think you have to go to UK to get the interview, and
Oral
also is
interview.
very expensive. As far as
Okay.
SQE1 is concerned, the exam is held twice, once in July and the other is in January.
Okay.
The exam cost, if I convert it into Indian rupees, is approximately 2 lakh rupees.
Okay.
So it is an expensive exam. But once you become a solicitor, but you remain a solicitor throughout your life.
All right. Yes. Yes, sir. And so you have also represented the Bank of Maharashtra in matters before NCLT, NCLAT and High Courts, and the Supreme Court also. Could you
Yes.
explain how one gets impaneled with a bank, and what is the selection or the interview process typically like?
See, you get a lot of advertisements if you are well aware on websites through contacts. So I got to know about this Bank of Maharashtra panel through a contact of mine. I immediately contacted the head office and they set me up for a telephonic interview at that point of time. They called for my CV and everything. And I was at that point of time just about to give my AOR exam. So I told them all that. They had a then I had a telephonic interview. They selected me for a panel. Now, being selected for a panel and getting cases are two different things now. A lot of people get selected in panels, but they don't get cases. So for getting cases, you have to then go and approach, call them, and once they see your work and they appreciate your work, then they automatically give you a lot more, many more cases. So they saw my work, I think, in High Court. Then I told them, they started giving me more cases in Supreme Court, and then slowly and slowly my practice and my relationship with the Bank of Maharashtra increased. That is the way you have to do it. Yeah. So you need your approach. You need to follow up and approach. There are two things that you
Mhm.
have to keep in mind, even after getting impaneled with a certain body.
Yes. I agree, sir. And you've been associated with the Supreme Court Legal Service Authority also for criminal appeals. Could you guide us through the
Yes.
process of getting impaneled with SCLSC? And was there an interview or assessment involved?
No, no. So there was this notification in the Supreme Court website. It was for advocate on records and also for advocates also. I filled up that form, and after I think 4 or 5 months, I get to know that I am now a panel member of the Supreme Court Legal Service Authority, and immediately I started getting cases. So I think I have now 4 or 5 cases from the legal aid Supreme Court, and it's very helpful actually because there are a lot of criminal matters which come, and mostly from we are from the obviously accused side,
Hmm.
and it's a very good experience, especially for young lawyers, because the cases can vary from a pickpocket to a murder case.
Yes. Yes,
Mm,
yes. And
mm,
sir, as an AOR handling criminal matters with the SCLC, what
mm.
kind of questions or practical scenarios were you tested on during the selection or empanelment process?
So, like I said, there was just a form which we had to fill. So there was no interview as such. So on the basis
Hmm.
of the form, they selected me.
Right. And
Mm.
you also served as a panel counsel for the state of Chhattisgarh before the Supreme Court.
Oh,
Could
that
you
was long back.
explain,
Yes.
right?
Mm.
So, could you explain how
Mm.
such government and panels work and what a young lawyer should prepare for, both in terms of eligibility and the interview or the selection stage?
So this state of Chhattisgarh panel actually was an eye opener for me because I was very excited. I got this panel. I also spoke with the standing counsel for the state of Chhattisgarh. He was
Hmm.
apparently not a AOR, and he wanted an AOR to file his cases, and that is when I realized the importance of being an advocate on record. And this was, I think, 3 4 years down my practice. So it was way back when I became a standing counsel for Chhattisgarh. Still, he gave me, because I pushed him a little. He gave me 1 or 2 criminal cases, but after that, the cases stopped coming. Maybe because of my, I didn't have that much experience, and maybe because I was not an advocate on record. So that this is where I got to know that just being a member in a body or being
Yeah.
impaneled will not help you get cases. So you have to go and seriously seek out cases and show that you are and you want to help and do cases. Yeah. So if you are a panel member of any state, that is very helpful because I was under a standing counsel in my that was my first you can say as a junior, my first experience after my LLB. You get a variety of cases in Supreme Court, and Once you become a panel member, a lot of responsibility lies on your shoulders because you're representing a state. So that is something which is very not only helpful, but also a very uh, highly responsible job if one has to undertake that.
Right, sir. And from a financial perspective, if I may, how
Mm.
viable is empanelment work for young lawyers, especially with institutions
It
like bank and legal services authorities?
very, 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 very. I think it's one of the best options financially also,
Right.
for experience also, for knowledge, for exposure, for everything. I mean, getting impaneled in any body, not only in bank, but
Mm.
uh, now there are empanelments in other central government offices also, in other offices. So you get empanelment anywhere.
Mm.
If you start getting cases, it's not only a viable option financially, but also for your own career and for your own exposure, experience, everything. So overall, getting empanelment, everyone, even from retired high court judges to even retired Supreme Court judges, if you see their career in the beginning, some are impaneled
Yes.
as a MCD advocate, or some advocate or some of the other. So they start being a member of the panel member of some body or the other, and from there they go on to become high court or then eventually Supreme Court judges.
Right, sir, right. And there is often the perception that empanelment requires strong connections. And so, in your experience, how much of it is merit based versus network driven? And how can a first generation lawyer break into such panels?
That's a very interesting question, and we all know the practicality here, and merit does matter, but obviously, as I told you before, also, your contacts and your connections matter slightly more.
Yes, sir.
Hmm. Hmm.
And so, lastly, how can law
And
students apply?
this is just a practical aspect I'm telling,
Yes, sir.
because ultimately we are in a real world. We can't fantasize and we can't be theoretical all the time.
Yes, sir. And as you
Hmm.
mentioned, it is true that even after getting an empanelment, it's not necessary they mark you the cases. It's totally based on your merit there, how you work with your network there. That is also merit.
Yes, you have to get on their back, and you
Yes.
have to regularly follow up, and then also not only do that. If they give you a case, you have to do a good job. See, winning and losing is not in your hands, but if they see that you are regularly appearing, doing everything on time, your drafting is good.
Yes.
So the first thing they notice you is through your drafting, and then they automatically will have trust in you and give you more cases.
Yes. It's similar to like working for our junior lawyers also. If you work in a law firm, you have to prove your worth. You have to
Yes,
show them that you're worth it. So it's similar. I somewhere agree, sir. And so
that is
lastly,
absolutely.
lastly, how can law students apply for internships at your office, and what should they do to stand out?
Oh, let me be very frank in this. I usually take interns who are in their fourth and fifth year, sometimes even third year also, but mostly from fourth and fifth year, because once they are in fourth and fifth year, they have the basic legal background, legal knowledge about things, and then I can give them drafting and all. Because internship in my thing is not a formality. They have to
Mm.
go to court. They have to learn how to file, and it's a proper internship, like as if you are working as a junior. So that
Yes.
is why I prefer students who are from fourth and fifth year. They can simply apply by giving their normal or detailed CV along with their other internships. And also I prefer students who are actually interested in litigation and not doing internship for the sake of doing internship to cover their LLB.
Yes. Yes, sir.
Hmm.
Sir, thank you so much. That's it from us. And thank you so much for sharing such candid and insightful perspectives on litigation, global legal education, and professional growth. Your journey from a gold medalist in the UK to an AOR at the Supreme Court of India
Yeah.
serves a powerful roadmap for aspiring lawyers. We are certain that your experiences and advices will help countless law students and young professionals who are navigating their careers with greater clarity and confidence. Thank you so much, sir.
You're welcome. Thank you so much. And it was a very, very good interview, and it was very nice talking to you.
Thank you, sir. Thank you.